Morrison Waite was born November 29, 1816 in Lyme, Connecticut. He was born into an upper-class family to mother Maria Selden and father Henry Matson Waite, who was a successful attorney, jurist, and a farmer. Waite's parents raised him as Episcopalian. As a child, Waite spent his days studying at a village schoolhouse, where he learned the basics of Webster's spelling book and Murray's grammar. He later studied Greek and Latin at the Bacon Academy, a prestigious private school, for a year. He was then accepted into Yale's class of 1837. It was noted by his fellow students, while at Yale, that Waite was a faithful, intelligent, and successful student. After graduating Yale, Waite studied law under his father, and in 1839 he was admitted into the Ohio bar. Morrison Waite gained the reputation as a distinguished lawyer in Ohio. In 1863, Waite declined an appointment to the Ohio Supreme Court. Later in 1871, Waite was appointed by President Ulysses S. Grant to be a part of a commission to settle claims against Great Britain by the United States, which arose out of the Great Britain's assistance to the Confederacy during the Civil War. The result of the proceedings were a compensation of $15.5 million to the United States. After this victory, Waite was elected to and was unanimously selected as president to the 1873 Ohio Constitutional Convention. Finally, during the convention, on January 19, 1874, President Grant appointed Waite Chief Justice of the United States.
Morrison Waite's most famous cases include Munn v. Illinois, United States v. Cruikshank, Minor v. Haberset, and the Slaughterhouse cases. In Munn v. Illinois, it was known that Illinois established maximum rates for their use in regulated grain warehouse and elevator rates. The question at hand was if the state-imposed rates denied equal protection and due process under the 14th Amendment to the warehouse and elevator owners. It was ruled that when necessary, states may regulate private property for the public good. In the United States v. Cruikshank case, the 1873 Colfax Massacre occurred, where a group of armed whites killed over 100 African American men as the result of a political dispute. 3 men were convicted of violating the 1870 Enforcement Act and appealed on the grounds of insufficient indictments. The Supreme Court sided with the defendants after its restricted interpretation of the 14th Amendment and the government's diminishing view on Reconstruction. In Minor v. Haberset, the court ruled unanimously that right of suffrage wasn't protected by the 14th Amendment. In the slaughterhouse cases in Louisiana, there was a partial monopoly of the slaughtering business that was given to one company. Competitors argued it to be unjust and that it abridged privileges and immunities. The question at hand was if that monopoly violated the 13th and 14th Amendments. The court concluded that the Privileges and Immunities Clause of the 14th Amendment applies to national citizenship rather than state citizenship.
On March 23, 1888, Morrison Waite died of pneumonia. He passed having served 14 years as Supreme Court Justice.
New York Times versus the United States. In 1971, the United States faced an issue on the limits that can be placed on the First Amendment with the New York Times. This case is about the Vietnam War, government secrecy, and the right to free speech and press. Robert McNamara was the Secretary of Defense in 1967. He ordered a study to be done about the Pentagon on the effects U.S. policy had on Vietnam War. Daniel Ellsberg worked at the Pentagon in the 1970s. He then came across the Pentagon Papers and wasn't pleased with the content contained in the article. It contained actions of the United States government in Vietnam, things such as illegal and secret bombings, the use of deadly chemicals, and negativity about the government. Copies of the Pentagon Papers were made and were dropped off at the New York Times. In June of 1971, the New York Times received the Pentagon Papers and published articles based on the articles they received. Nixon reads the newspaper article and uses his implied powers to issue prior restraint, which means he was able to stop the press from releasing any more information. They used the Espionage Act to claim that it is a national security issue. Nixon believed that the New York Times was putting the government in danger. Authorities gave the president an okay to issue prior restraint. The New York Times fought for their right to publish the papers under the protection of the First Amendment. The case went to the Supreme Court because the U.S. argued that the New York Times violated the right of the First Amendment. The New York Times versus U.S. was not the first time the U.S. Supreme Court heard a case regarding rights under the First Amendment. Warren E. Burger is a Chief Justice and heard the case in the Supreme Court. The Supreme Court faced a difficult decision regarding the applicability of the First Amendment and to what extent the constitutional rights granted should be implemented. The key factors it considered was whether or not the publishing of the Pentagon Papers proved to be a danger to national security and whether or not the people had the right to be informed, as well as a justification for rendering a decision for either party can prove to be detrimental circumstances in the form of future precedents for constitutional interpretation of the laws. Associate justices of the Supreme Court had been in disagreement in the final verdict and even had reservations about considering this case for a hearing. The court eventually granted their decision to the New York Times, holding that the First Amendment rights of the constitutional. The Pentagon Papers were ruled in favor of protecting the First Amendment right. This later became used as a precedent for further cases involving the freedoms granted by the Constitution. The Supreme Court ruled the First Amendment protected the New York Times against publishing and printing materials.